For years civil libertarians hoped to end California's practice of taking DNA from people arrested on suspicion of a felony and keeping that hereditary information in an offender database, no matter if the suspects were later acquitted or had their charges dropped.
That fight for more protective rules in the government's DNA collection suffered a major setback Monday when the California Supreme Court let stand a provision of a 2004 voter initiative that said any adult arrested or charged with a felony must give up his or her DNA.
On a 4-3 vote, the state's highest court refused to throw out that part of the Proposition 69, which has led to the storing of DNA profiles of tens of thousands of people arrested but never charged or convicted.
Justice Leandra R. Kruger, an appointee of Governor Jerry Brown, wrote Monday's ruling, a victory for prosecutors. The court's 3 more conservative justices joined her.
Brown's 2 other judges on the state high court and a Democratic appointee on an appeals court dissented. Kruger stressed the majority ruling was narrow and applied only to the facts of the case before the court. She said the DNA program for arrestees could still be challenged by someone else at a later date.
We recognize that the DNA Act may raise additional constitutional questions that will require resolution in other cases, she wrote. The more liberal justices wanted the court to use the opportunity to strike down a DNA program they said affects thousands of innocent people each year, and disproportionately African Americans. Of the 200,000 to 300,000 people arrested in California annually on suspicion of a felony, about a third are either acquitted or never formally charged.
Yet the genetic profiles of the vast majority of them remain in a DNA offender database and can be combed by law enforcement to search for suspects in crimes.
The fact that felony arrests of African Americans disproportionately result in no charges or dropped charges means that African Americans are disproportionately represented among the thousands of DNA profiles that the state has no legal basis for retaining, Justice Goodwin Liu wrote in one of Monday's dissents. By allowing for the retention of DNA profiles of people not even charged with a crime, it is not that far a step for the state to collect and retain DNA from law-abiding people in general, Liu wrote. The case was brought by Mark Buza, who refused to have his DNA taken after San Francisco authorities arrested him on suspicion of arson and related felonies in 2009 and took him to jail. But the court majority, pointing out that Buza was convicted, eventually had his DNA taken and never tried to have his genetic profile expunged, decided his case was not the right forum for tackling constitutional questions affecting the innocent. Justice Mariano Florentino Queller, Brown's other appointee on the 7-member court, agreed with Liu and Court of Appeal Justice Dennis M. Perlas that the arrestee provisions violated California's constitution.
Perlas, appointed by Governor Gray Davis, helped decide the case because the state's highest court has a vacancy.
The DNA Act unlawfully invades people's reasonable expectation of privacy in their personal genetic information, he said. Any diminished expectation of privacy arrestees may or may not have in their genetic code does not justify an intrusion of this magnitude.
Because Monday's ruling did not upend Proposition 69's requirements, the protections for innocent arrestees added in the new law will not now take effect.
4:20 p.m., this article was updated with reaction, background and additional details from the decision.